This is 215141 GC, Michigan Schools Government versus Tandra Reeves. May I have your appearance, please?
Good morning, Your Honor. Jeffrey Beers, P 41693 on behalf of plaintiff Michigan Schools.
Tandra Reeves. Today is a day and time set for the final pretrial motion for summary disposition. This matter was scheduled at 9 o'clock. It is now 9:15 by the court's clock. Defendant has failed to appear this morning and did not file a written response to the plaintiff's motion for summary disposition. Is there anything you'd like to add to your motion, Mr. Beers?
Your Honor, as our motion is unopposed, we ask that it be granted and that judgment enter the amount of $4,300.78, which represents damages of $4,051.78, court cost of $174, statutory attorney fee of $75, for a total amount of $4,300.78. Proposed order at the bottom of the stack.
Thank you, Mr. Beers. This court has reviewed your motion and all attachments in its entirety. Based on the defendant's failure to file a written response or appear this morning, motion for summary disposition is granted as prayed in plaintiff's motion. Mr. Beers, the court has signed the order granting that motion for discovery and judgment that was attached to the motion. Anything else in this matter, sir?
Thank you, Your Honor, and have a good day.
You too, sir. Good to see you.
See you. Goodbye.
Thank you. Who is this in Wayne County Jail?
Good morning, Your Honor. I have a tether violator, Aisha Moore.
Are you for arraignment?
Well, a tether violation.
Tether violation. I don't have anything scheduled this morning. Mariana will check and see where you are supposed to be. I know you like logging on with me, but I'm not arraignment
Oh, I
this
love
morning.
your
You
court.
want violation.
What was your judgment for? Was it Oakley or?
To get the tether?
Yeah.
It was in Romulus.
Well, this is wrong.
Miss Green Brown Green?
It could be Brooks Green.
Or yeah. I seen her once in the beginning, but throughout of it, it was Miss Green Brown.
Judge Green.
Yes.
Is that where you're supposed to be?
That was my judge on the Romulus case. That's the one who sentenced or me the tether.
Is Judge Green in this morning, Your Honor?
She is, sir, and she should be on the bench. Do you need her number? Do you have it?
Actually, I have it, Your Honor.
She's
Thank you,
here.
Your Honor.
All right, you have a blessed
Have
day.
a good day. You
Thank you,
too.
ma'am.
Thank you. Good luck to you, ma'am. This is 221840 GC. This is Citibank versus Julie Laren. May I have your appearance, please?
Good morning, Your Honor. Preston Nate, P77884 for Citibank.
Good morning, Mr. Nate. Today is the day and time set for your pretrial in this matter. It was scheduled at 9 o'clock. It's now 9:18 by the court's clock. Defendant has failed to appear. So, sir, how are we proceeding this morning?
Well, just to update the court, the defendant is working with a debt settlement company who did contact our office. They were able to work out a payment plan. She did make the first payment. If the court would be willing to maybe adjourn this pretrial 30 days, we can try to get a consent judgment instead of just defaulting her, because I know she is making an effort, looks like. She probably didn't appear, thought it was resolved, but that's the update. So if we can get a little bit of time, we can probably get a consent judgment into you.
Sir, if you want an adjournment, this court is happy to give it. That adjourned date will be September the 6th at 9:30 a.m. Anything else in this matter, sir?
In this matter, no, Your Honor, that would be great. Thank you.
Thank you. The civil department will send out notices. We are still on Zoom back here in courtroom number 1 for this adjourned case. Thank you.
You bet. I'll stay on, Your Honor. I do have a 9:15 with you, so we'll see if she appears.
With Ms. Haskey, I see that. Thank you.
Yep.
I just got a call. She is signing in from our probation room right now.
I see that note. So Mr. Nate, as soon as she gets logged on, we'll get you into a breakout room if there's something for you. I saw there was an offer in the file, so you can discuss that with her, and then I'll get the case call when you pop back out.
That would be great. Thank you.
And at Mary Ann, I can work on this thing right here. Ms. Rab, your case is scheduled at 9:30, and as soon as we see someone from Beaumont Health pop on, we'll get you matched up and into a breakout room to discuss the case, okay?
Okay, yes, ma'am.
Marianne, I don't know if you saw this story. These people driving out in Chesterfield Township, 120 something miles an hour.
I did see that.
I can't imagine going that fast. The minivan, I think, has top speed of 85, but whatever. There's this thing on TikTok where this guy is describing what the lanes of travel are for, and he called the left lane the lane for people with ticket money. And I'm thinking at 120 something miles an hour, you're probably in the ticket money lane. Darren Green. Mr. Green,
Yes, ma'am.
what are you here for this morning, sir?
I think I got an appearance today for hearing the eviction hearing, or tomorrow. I'm not sure.
Mr. Green, what type of case is it, sir?
It's an eviction case. I'm not sure if she said the second or the third. I wanted to make sure.
Mr. Green, hold on one second, sir. My question to you is what type of case is it?
Oh, let me look at the paper. It's a summons.
Oh, okay, Mr. Green, in the top right-hand corner, there will be a case number.
Yeah,
What is that case number, please?
22-3229 LT.
Okay, Mr. Green, that is tomorrow morning at 9 o'clock. You're back here with me, but that is actually August the 3rd, sir.
Okay, thank you.
I'll see you tomorrow morning, okay?
All right, see you then.
Have a good day.
You too.
Thank you. Ms. Chambers?
Hello.
Your case is not scheduled until 10 o'clock. You're welcome to stay until
Okay.
that time, but I don't expect Pallett's Law Firm until a lot closer to 10 o'clock, okay?
Okay, I can come back then.
Okay, thank you, ma'am.
Thank you.
Are they having problems logging Ms. Haskey in, or is there somebody else in the probation?
There's somebody else using the computer. So they're just waiting, she's just waiting. Do you want me to have them bring her into your courtroom?
I was thinking that, but Mr. Nate needs to speak to her.
Oh,
I
okay.
I don't know if their conversation is one for open court, but I wish there was some place else for her to log on. I don't know if any of these upstairs offices have computers in them that somebody could potentially use.
I don't know if it would help the court having her come in person. I don't think I would probably object to her request from her answer, if that's still something that
Oh.
works for her.
I was hoping that was gonna be your response, Mr. Nate. Yes, Mary Ann, if you would have them bring her up, I'd appreciate it.
Sure.
Yeah, so there wouldn't really need to be much back and forth. I would have just made sure that still sounded okay with her and she was still on board with doing that.
I appreciate that, sir. Thank you.
Yeah.
Good morning, Mr. Mubarak.
Good morning. How are you, Your Honor?
I am wonderful, sir. How are you?
I'm doing well, thank you.
I have not
Well,
seen
back on
Mr.
this.
Camilleri yet, so if you would sit tight, as soon as he gets here, we'll get your case called, okay, sir?
Thank you.
Thank you. This is 222631 GC. This is Midland Credit Management versus Kristen Hask. May I have your appearances, please?
Preston Nate, P77884, appearing for Midland.
State your name, ma'am.
I'm Kristen Haskey.
Ms. Haskey, thank you. Today is the day and time set for the pretrial in this matter. Mr. Nate, how are we proceeding this morning?
I would like to just ask Ms. Haskey, I didn't have a chance to read your answer. It sounds like you're kind of going through some rough stuff, and I get that. You indicated that maybe you'd be able to make a payment plan of $25 a month. Is that still something you'd be interested in?
Yeah, that's about all I can do right now.
Okay. I don't have any issues with that. So if that's something you feel like you can afford, I can do that.
Okay.
So
Ms.
what would
Haskey, when will you make your first payment?
I can shoot for like the end of this month.
that works for me. That's fine.
Okay. And then consistently, I'll do about the same date at the end of every month.
Are we saying August 31st or a few days earlier, Ms. Haskey?
Let's see. Where's the calendar? The 26th will be fine.
August 26th and then the 26th of each month thereafter?
Yeah, that would be fine.
The plaintiff's office will send you a consent judgment that has that payment plan on it, along with the amount they sued for plus their court costs. When you get it, if you sign it and you send it back, Mr. Nate's office will sign it, send it to the court, and then the court will sign it. You'll get a copy with my signature on it. That sets your
Okay.
payment plans at $25 per month, beginning August 26th, okay?
Okay.
Mr. Nate, if we don't have that signed consent from you within the next 3 weeks, you're likely to get a no progress notice from the civil department, okay?
That sounds fine. Yeah, we'll get that prepared now.
Thank you. Anything else, Mr. Nate?
No, that'd be great. Thank you, Your Honor.
Anything else, Ms. Haskey?
Nope.
Thank you. We're all set. Ms. Haskey, you may just leave that room that you're in. The
Okay.
officers will come take care of the computer end of it. Mr. Nate, did you have anything else with us this morning?
I believe that was it, Your Honor. Thank you.
Thank you, sir. Have a wonderful day.
Thank
too.
you.
Thanks, Ms. Haskey.
Thank you. Take care.
Hmm. So Mary Ann,
Yes, ma'am.
I started watching on Netflix. Why can't I think of the name of it? Ashton Kutcher, Sam Elliott, and Deborah Winger.
Huh, I like the three
From,
of those actors.
I know from 2020, I think is The Ranch. That's the name of it, The Ranch. Sam Elliott and Deborah Winger?
They haven't been around for a while. Is it a movie or is it a series?
It's a series. I thought about it because, Kevin keeps making fun of me that I'm watching some of the weird stuff. I watch one thing and it just rolls over into something else. It's newer. Oh, wait a minute. Oh, I thought it was more 2016. No, I didn't realize it was.
Is it good?
It's interesting. It has canned laughter, which kind of throws me off a little bit. But Ashton Kutcher, I hadn't seen him. I couldn't remember last time I saw him. Sam Elliott, same thing. And it took me probably 2 episodes to realize that Deborah Winger was Deborah Winger, because it's on in the background. So it's on and I'm listening, but I'm not watching. And I happened to glance up and I was like, wait, that's Deborah Winger. Married to Sam Elliott. Well, married on the show to Sam Elliott. But it's about a high school. He was a high school quarterback who's now like in his early 30s. He's still trying to go pro and blah, blah, blah. Comes home for tryouts for some semi-pro team and winds up staying to help his dad run the ranch. And it's interesting. I never would have picked it. If I read the summary, I never would have picked it. But because it came up, because you watched this ridiculous thing, here's this other ridiculous thing. That's how I wound up. He just walks in, looks at the screen, shakes his head, and keeps going. Like, what are you watching now?
I get that. But Deborah Winger, oh my God, I haven't seen her in anything in whatever that last famous one that she was in.
She looked great, and it caught me off guard. And what was it? Purple Hearts. That was it's a movie that came. This is what happens when I'm cleaning on the weekend. The Netflix has its own mind, and I didn't recognize any of the actors in the. It's a typical romantic comedy. This improbable couple meets and they get together for the wrong reasons, but then they fall in love and that kind of stuff. Purple Hearts.
Now that's a
movie
movie
on Netflix.
Did you? That's a movie.
It's a whole movie, and I watched it, and he's like, I don't know how you watch this stuff because it's on. I'm not sitting, staring at it like that. But what I'm doing is I'm reading or I'm cleaning or folding laundry, and in the back of I'm like, oh, that's interesting. And now that you're 40 minutes into it, you might as well finish it. So
of course.
It's either that or watch dancing cat videos all day. So it's.
Well, I don't know. I think I would kind of do that.
I saw it was a Roomba with this small cat bed on top of it, and this cat sitting in it with the Roomba driving the cat around. And I should have sent it to you when I saw it. It was funny. It was funny to me, but Oh. I'm just waiting for 2 more minutes. There were 2 cases that were going to be dismissed. I was waiting for the stipulated dismissal to come back by from the parties. And then this third one where there's no attorney. So we will figure that out here in 2 seconds. Sam Elliott, I just remember him. What was the movie where he says, that was Sam Elliott from back before Man Buns. He's the man's man. I think we need the property manager ladies back from last week. They were fun. This is 221360 GC JP Morgan Chase Bank versus Frederick Fitzgerald. Today was the day and time set for the adjourned pretrial in this matter. The court did receive from the plaintiff's attorney a dismissal of the case and rejected it as it's not stipulated to. And Mr. Fitzgerald filed an answer based on the previously indicated intent of the parties and their failure for either party to appear this morning. The court will dismiss this matter without prejudice. This is 221361 GC. This is also JP Morgan Chase Bank versus Frederick Fitzgerald. This court in this case received a dismissal from plaintiff's attorney, again, because Mr. Fitzgerald filed an answer in this case. The court was expecting a stipulated order to dismiss and rejected the previously submitted dismissal by plaintiff based on the failure of either party to appear this morning. The court will enter a dismissal of this matter as previously indicated was the intention of plaintiff's attorney. This is 222176 GC. This is Beaumont Health versus Tanisha Rab. State your name for me, please, ma'am.
Tanisha Rab.
And
Ms. Rab, today.
Home 1 week from yesterday. You understand that?
Thank you, Mr. Camilleri. Ms. Rab, today is the day and time set for the pretrial in this matter. Have you had any contact with an attorney from Beaumont Health?
I just received some notice to appear in the mail and some items in the mail, like a motion, but like no phone contact.
Okay, ma'am, what is it that you received?
This is a motion for summary judgment and memorandum support.
In this case?
Yeah.
In the upper right-hand corner, does it say 222176?
Yeah, it's the letter C behind it. C as in cat. The letter C behind it.
GC, yes, ma'am.
That's all I got.
Give me one moment, Ms. Rab. I see that that document was received and returned to plaintiff's attorney. But ma'am, we have the case scheduled this morning at 9:30 a.m. for the first pretrial conference. It's now 9:48 by this court's clock. Inasmuch as the plaintiff has failed to appear this morning, this matter will be dismissed. Ma'am, that dismissal is without prejudice. The plaintiff's office can request that the case be reopened, reinstated, okay? So if you receive something in the mail indicating as much, you need to appear or respond, okay?
Okay.
And ma'am, for the underlying dates of service, have you submitted them to your insurance company for payment or consideration?
You know what? I've been in contact with a lot of those are my daughters. And normally what my insurance doesn't cover, my daughter's the father insurance covers.
Ms. Rab, I don't want you to have to disclose all that. I just want you to stay on top of it.
Oh,
no,
okay.
You're fine.
Yeah.
Just in case Beaumont files to reopen the case, I want you to be moving.
Okay.
Towards getting the stuff taken care of. That's all.
Okay.
Anything else?
No, that's it. Sorry.
As far as this case?
No, I'm okay. Thank you.
You have a wonderful day, okay?
Bye-bye.
Thank you. Bye-bye. Mr. Camilleri, Mr. Mubarak is here. Did you want to speak to him?
I'm mute still.
I know.
Okay,
Maybe he's in another courtroom.
okay.
Yep, I see his lips moving. As soon as he's done with that, whatever he's on, Marianne will get you into a breakout room and see if you all can come up with a resolution or some direction on how we're proceeding this morning.
Thank you.
You're welcome. Thank you.
Judge, can you hear me?
Yes, now I am able to. Mr. Camilleri, do you want to speak to Mr. Mubarak?
Sure.
Marianne will get you into a breakout room with him when you come out. I'll get your case call and get you on your way.
Thank you, Your Honor.
You're welcome. Christian Payne. Good morning, Mr. Morton.
Morning, Your Honor.
How are you, sir?
It's another beautiful day in Michigan.
You, Ms. Chambers was here. I told her to log back on closer to her start time, so she should be back momentarily.
Okay, when she logs in, I'm more than happy to be able to speak with her, Your Honor.
And thank you. And we received the dismissal in the Ori matter.
Correct, yeah, so there should only be 3 matters left on the schedule, at least from my office.
Thank you.
Thank you.
This is 222306 GC Carl Dollins versus Dave Olson doing business as Olson Cement. May I have your appearances, please?
Good morning, Your Honor. Ali Mubarak on behalf of the plaintiff counter defendant Carl Dollins.
Morning, Your Honor. Attorney John Camilleri, behalf of Dave Olson.
Thank you. This matter was previously a small claims matter that has now been removed to the general civil docket. The attorneys have had the chance to speak this morning. How are we proceeding, Mr. Mubarak?
Your Honor, I've had the opportunity to speak to counsel, and we're thinking to go to like mediation, like if that's an option, if you're okay with that.
We can do mediation. We actually have Judge Green, who is a ICO certified mediator in the building. We can send the file to her to allow you to schedule a mediation with her if that's acceptable.
I'm okay with that.
Fine, Your Honor. Yeah.
And what I will do is set you as an adjourned pretrial with me on October 4th, October 4th.
Judge, I'm out of the country from the 1st to the 16th. We're going to see our daughter.
November 1st.
Yeah. Oh, you said November?
I said October originally, but now I said November based on your travel issues.
Thank you, Judge. Sounds great.
Mr. Mubarak, is that a good day for you?
Yes, ma'am. The November 1st is perfect.
We'll say November 1st, 2022 at 9 a.m. back on Zoom with me. I'm calling it an adjourned pretrial, but I'll treat it more as a control date to make sure that you get in with Judge Green. We've had this conversation, so we've been going back and forth. She and I are both ICO certified mediators, so I'll send this file down to her, get you scheduled, and then if you resolve it, great. Otherwise, I'll see you back here on November 1st. Anything else on behalf of the plaintiff?
No, thank you, Your Honor.
Anything else on behalf of the defendant?
Nothing, Judge. Thank you very much.
Thank you. You both have wonderful days. I hope
You
not to
too.
see you.
Thank you, Judge. You too.
Thanks, John.
Bye-bye.
Bye-bye.
Ms. Chambers,
Hello, I'm present.
Mr. Morton is here. If you would like to go into a breakout room to discuss this case before I call it, okay?
Okay.
Thank you.
Ms. Chambers, you should see an invitation to join the breakout room. If you could just click on that, please.
I don't see the invitation.
Ma'am, what kind of device are you using?
A gateway laptop. It says the host has open breakout rooms. Please wait to be assigned.
Mary Ann, would you make me co-host, please? Ms. Chambers, do you still not see the breakout room?
No, ma'am.
Okay,
It's still okay. I
now
see.
you should.
Okay, I do now.
You see it now? I cannot believe we're scheduling stuff in November already. This is 221734 LTGI versus Jaleesa Chambers. May I have your appearance, please?
For the record, Your Honor, Attorney Ian Morton of Pallets Law on behalf of the plaintiff.
Jaleesa Chambers, I'm here, the defendant.
Thank you. Today is the day and time set for hearing on plaintiff's motion to reinstate dismissed case and hold immediate hearing. Mr. Morton, you've had a chance to speak to Ms. Chambers. How are we
Yeah.
proceeding this morning?
Yes, Your Honor. The parties have come to a resolution and agreement. The matter will now be listed as formally conditionally dismissed. Was it upon agreement that Ms. Chambers has agreed to vacate on or before August 12th, 2022.
I'm sorry. Wait.
Okay,
It's a non-payment of rent case, correct?
yes. So it's an agreement, and I'll give the short version, Your Honor, before I put all the formal terms. She's going to vacate by 8/12, which will result in her entire balance being waived and not being collectible at all.
I'm sorry, August 12th?
August 12th.
That was the short version. What's the long version, Mr.
The longer version, Your Honor, would be the fact that the parties have agreed that Ms. Chambers will vacate on or before August 12th, 2022, which was it, and that will be represented, the turnover will be represented by her turning the keys over to the management. Further, the total balance due, which at this time is $3,586, will be deemed waived and not collectible. Was it if possession is received on or before August 12th, 2022. If it is not received by that point, then the waiver is void and my client may move forward to seek possession. But was it, we spoke about this beforehand. I also advised her of her rights under MCR 4.201, the fact that she has 3 business days until this agreement is final to file a motion or a request to set the agreement aside. She also provided me her permission to sign her name to this agreement.
Ms. Chambers, you heard the comments Mr. Morton just made.
I'm sorry, I couldn't hear you.
I said, you heard the comments that Mr. Morton just made?
Yes, ma'am.
And ma'am, that's your agreement?
Yes, that's my agreement to turn over the keys by the 12th. I had a situation anyway. My father just passed away, so I had to move to help my mom. So I kind of did want to end the lease if possible. And I do, Sarah, they're paying a portion of what's due, but it would still be more left and I would still have the lease. So I feel like it's probably in my best interest to vacate.
I'm sorry. So Sarah is paying a portion of this $3,586?
Yes, ma'am. I was approved on June 29th for $2,859.
Okay. So Mr. Morton, is your client not accepting this $2,850 or have they already accepted it and applied it and the $3,586 is what remains?
No, Your Honor, she had 2 pending Sarah applications since we were last in front of the court. One has been received, which I advised Ms. Chambers had been received and been applied. This other one, my intent, Your Honor, based on the fact that moving forward, the termination is I'm gonna tell my client they need to return the funds. However, as I said, it does not impact Ms. Chambers' waiver because Ms. Chambers will receive a full waiver of her balance as long as possession is turned over by the August 12th date.
Okay. Ms. Chambers, I'm asking both you and Mr. Morton these questions because this is a non-payment case. He is indicated to the court that the parties have agreed to convert it to a termination case, which is a different notice requirement. And I just wanted to make sure that you were fully aware of what this conditional dismissal means and that this is what you want to agree to. So if that is in fact what you want to agree to, and you've authorized Mr. Morton to sign your name to a conditional dismissal that indicates that the plaintiff will waive $3,586 in rent and deem it as non-collectible so long as you turn in your keys and surrender possession of the unit to the plaintiff on or before August 12th, 2022. He'll draft that conditional dismissal, sign his name to it, sign your name to it, and sign and submit it to the court for signature. And that's, ma'am, how you wish to proceed this morning?
I believe so. Am I allowed to ask, is that saying like I was evicted like from the lease, or like would that be on my credit, or?
If I may, Your Honor.
Absolutely.
One of the reasons we're entering this as a conditional dismissal is therefore that I can't tell you 100% how it will be reported when agencies get a hold of information from the court, but you will have a conditional dismissal, an order that says the case has been dismissed. And as long as you turn over possession by the 12th, if for some reason it gets reported as an eviction, you will have that legal document to be able to show that you were not evicted. You entered into an agreement and the case was dismissed. That's why we're going to do it as a conditional dismissal, not as a judgment.
Okay, that's fine, Your Honor. Yes, I agree.
Okay. So again, Ms. Chambers, Mr. Morton will draft that document, submit it to the court for entry. And a side note, your motion to reinstate your dismissed case is granted. I understand that that's more of a procedural thing than anything else. Ms. Chambers, because your landlord is represented by an attorney, you are not, the document that this court receives will not be final and enforceable for 3 days. Okay, ma'am?
Okay.
Anything else, Mr. Morton, in this matter?
No, Your Honor.
Anything else, Ms. Chambers?
No, ma'am. Thank you.
Ma'am, good luck to you again. Condolences to your family. Have a good day.
Thank you.
Hmm.
Hi, good morning, ma'am. Can you hear me?
Yes,
Hi, what case are you here for this morning?
Rourke and Metro Commons, he's still fighting in.
What, who is the defendant?
Lev Rourke,
Oh, okay. Are you on the lease? Are you with the?
yes, I live here.
Okay, thank you. Hi, good morning, Mr. Layman. How are you?
Fine, thank you. How are you?
I'm well, thank you. I have Mr. Rourke And Ms. Thomas, do you want to go into a breakout room with them?
I think, I'm trying to remember. Looks like there's at least one CRA application that's pending, so that's fine. I'm happy to talk to them.
Okay, thank you.
Already. Building inspector was subpoenaed and present. Ted McCabe signed the judgment. Was
It's breakout room number 3, Mr. Landon.
Nope, not Miss Kennedy. Oh, you know what? Mr. Payne finally moved. Let's bring him back. Let's see what we can figure out for him.
Do you want me to remove him and see if he comes back?
I put him to move into a breakout room to try to get him to connect his audio. Then he connected it on his own. And I'm trying to get him to turn his video on or his camera so that when Levine's office does appear, we can get going without all this who shot John, but let's. Mr. Payne. Christian Payne. Christian Payne. Mr. Payne, this court has sent repeated requests for you to unmute or start your video. I understand you're there, sir. Why are you not responding? The case will be called as soon as the attorney's office comes out of the breakout room. Sir, you can unmute yourself by pressing that button. Good morning, Mr. Landman.
Hi, I have finished with Mr. Rourke, but they, I think, are still stranded in the breakout room, Your Honor.
And Mr. Payne is here, but seems to have some inability to unmute and turn his video on. So we'll try to work through that in a second here.
Okay, I
This
see
is-
he's got his chat up, which is good.
That's good, but the easier part is to click the button with the video camera and the microphone on.
I
But before we
agree.
get there, this is 221582 LT. This is Metro Commons versus Rourke. May I have your
Good-
appearances, please?
Yes, good morning, Your Honor. For the record, Daniel Landman, P35797, on behalf of the plaintiff.
Rourke, please state your name for the record.
My name is Vlad Rourke.
Thank you. Today is the day and time set for hearing on plaintiff's request to lift the Sarah stay that went into place on May the 4th, 2022. 91 days have passed since entry of that stay. Mr. Landman, you've had the opportunity to speak to Mr. Rourke. How are we proceeding this morning?
I did, Your Honor. My understanding is that Mr. Rourke's Sarah application is still pending. I would like to request of the court that the stay be lifted. However, rather than asking for a judgment today, based upon the information that was made available to me, I would request that we put this case over for another 2 weeks. And hopefully that will allow the processing to be completed. It was an original Sarah application, Your Honor, so Mr. Rourke should be eligible for a payment that would bring his rent current in full.
I don't know if it will be 2 weeks. I'm looking at maybe. Well, it may be 2 weeks. Let me see what else we have going on August the 16th. Oh, Mary Ann. Mr. Landman, I don't think that's going to work. It's more like August the 30th.
That's okay, Your Honor. It's still before the end of the month. I'm fine with that.
If you're available, okay. And Mr. Rourke, are you available on August the 30th, sir?
Yes, I am.
Okay. We will say August the 30th at 9 a.m. Mary Ann doesn't like we have anything else scheduled that day. Might start putting some things on there. August the 30th at 9 a.m. The court civil department will send written notice of that date.
Do we still have to come in tomorrow? Because we have the court date today and tomorrow.
What's tomorrow?
It's the one that was actually on the eviction notice, like this, the court hearing for today was on a
Ma'am,
separate, like.
I'm sorry. Who are you?
I am the person that lives in this house that take care of those.
That's, okay, let me ask it a different way, clearly. The only person listed.
I'm on the lease. I'm not sure why it's not on the court paperwork, but I am on the lease.
Okay. Where I'm going with this is I'm trying to see. I don't have you on this case, and typically if you're not a listed party, you're not allowed to participate in the proceedings. But if you give me 1 second, no.
Your Honor, she is an authorized occupant on the lease. She did not sign it, but she is listed as
She's
an
not
authorized
listed as a
occupant.
party, Mr. Landman, and this court's process is typically not to allow people who are not listed parties to participate. But
Ma'am,
my
I thought
bigger
they said-
concern is that, hold up, ma'am. My bigger concern is that if we have a pending landlord tenant case that is in Sarah State and plaintiff's office filed a new case that is now scheduled for hearing tomorrow with Judge Oakley, or sorry, my resolve at 11 a.m., that's problematic. Why a second case will be filed while Sarah stay is pending, that's a bigger issue.
I wonder whether tomorrow's case is a termination of tenancy case, Your Honor. I
It's
agree.
not,
There's
it's a non-payment of rent case. I'm looking right at it. It's
Well, there-
223337 LT.
I agree
Non-payment of
completely with
rent
the court.
case.
Yeah, it should not be pending. It should not have been filed. And I will see that we submit a dismissal on it.
Hello?
Ms. Thomas, ma'am, I
ma'am.
was not trying to be rude to you, but I'm trying to do the process here so that you don't have to come to court twice. And I just need you to let me do the part I'm trying to do so we can kind of get through this thing. We're adjourning this case 221582 LT to August 30th, 2022 at 9 a.m. It'll be back on Zoom, back with me in courtroom number 1. Mr. Lamon has indicated that 223337 LT that's scheduled for August the 3rd at 11 a.m. is going to be dismissed. It should not have been filed because there is a pending non-payment of rent case that was subject to Sarah's stay. Now that there is a new date, I'm not sure if that will cause your Sarah application to receive some priority treatment. If not, when the parties reappear on August 30th, be prepared to discuss how we will be proceeding with the unpaid rent, okay?
Yes.
Okay.
Anything else, Mr. Lamon?
No, Your Honor.
Anything else, Mr. Rourke?
No, that's it.
Anything else, Ms. Thomas?
No, thank you.
Have a good day. I'll see you on August 30th. Thank you.
Thank you.
Thank you.
Mr. Payne,
I'm here. Can you hear me?
I can hear you now, sir. I'm not sure what was going on before.
I believe
I
it
need
was
you-
probably my tablet, so I had to download it onto my cell phone.
Thank you for being persistent. There is an attorney here for Swiss Tech Levine for Metro Commons. We're going to send you into a breakout room to speak with him, unless,
Okay.
Mr. Lamon, you have an update already.
Your Honor, I do not. This was not a SIRA case. This was an ERAP case, and I don't know the status of the application.
Okay, then let me call it 221581 LT, Metro Commons versus Christian Payne.
For the record,
Payne.
Daniel Landman on behalf of the plaintiff.
Christian Payne here.
Mr. Payne, have you received an update regarding your ERAP application?
Yes, it was approved, but I am going through a dispute right now with the Money Network because the card was not, it was sent out, but it was not placed in my mailbox. It was stolen. And so I'm going through the dispute right now with the Money Network. I have my dispute forms right here with my dispute claim because I need those funds to pay my rent. And I already had let Metro Commerce know when it originally happened. So I have kind of shocked that I had to come to court today, but I understand why, because they want their back owed rent. So I understand that. And I do know how much the current balance is, how much I do owe them, but I do know how much I was approved for through the ERAP.
How much were you approved for, sir?
25, so 2,525.
Mr. Payne, we're here this morning on a plaintiff's request to lift the Sarah stay that was put in place back on May the 4th, 2022. That stay is a 45-day stay. We are now at 90 days since entry of that stay. Mr.
Yes,
Lamon,
ma'am.
how do you wish to proceed this morning?
Your Honor, based upon the fact that if the money is finally transferred over, it would be $2,500. That would be enough to bring Mr. Payne's arrearage current. With that in mind, I have no objection to adjourning this case to August 30th as well, with that being a final adjournment. Mr. Payne is going to need to do whatever is in his power to expedite the resolution of his dispute so that hopefully that money can be paid before the next court date.
Yes, I understand that.
Mr. Payne, we will adjourn this case over to August 30th, 2022, 9 a.m. back here with me in courtroom number 1 by Zoom. That gives you some time to follow up on your dispute with the payment network.
Yes, ma'am.
Anything else, Mr. Payne?
No, that you've been very helpful. Thank you.
I'll see you at the end of August, sir. Have a good day.
All right, you too.
This is 221476 LT West Village Estates versus Samantha Vaughn.
Daniel Landman for the plaintiff, Your Honor.
Samantha Vaughn. Today is the day and time set for a hearing on plans request to lift the Sarah stay. Scheduled at 10:30 a.m. It is now 10:53 a.m. by the court's clock. Defendant has failed to appear. Mr. Landman, how do you wish to proceed?
Your Honor, we have no updates on the status of Ms. Vaughn's Sarah application. Based upon her failure to appear, we would move for the entry of a default judgment for possession only. Based upon my client's books and records, the rent to retain is $4,059.56. Costs are $164.53. So that would be a total of $4,224.09. We would request that if the court feels inclined to enter the judgment, that an order of eviction issue after August 12th, if that amount is not paid current.
Matter having been scheduled at 10:30, it now being 10:53 by the court's clock, defendant having failed to appear, plaintiff's request to lift the Sarah stay is granted. And based on defendant's failure to appear, default judgment shall enter with rent to retain of $4,059.56. Court cost of $164.53 for a total due and owing of $4,224.09. Written date of August 12th, 2022. Mr. Landman, if you could have your office submit that default judgment.
We will do that today, Your Honor.
But before you go, there's somebody connecting. And before we, to the person who just joined us on the iPhone. Hello?
Yes, can you hear me?
Yes, your name, ma'am?
I'm Samantha Vaughn.
Ms. Vaughn, you were supposed to be here at 10:30. The court just called your case.
I'm sorry. I'm under the weather. That's why I had took medicine and everything. I'm sorry. My time, it went by me.
The attorney is here, ma'am. Do you have an update on your Sarah application?
The only thing they said, my application was accepted and submitted, and that was it. And they told me that the Salvation Army had took over my case. And that's all the information that I had. So I didn't know what to do after that. If I'm supposed to wait or if I'm supposed to just start paying myself right now, because it's been over about 3 months now already.
Mr. Landman.
Your Honor, in the interest of being consistent, I reluctantly I appreciate Ms. Vaughn getting online. I would not have any objection to the court vacating the judgment which it's just entered and giving Ms. Vaughn till August 30th at 9 a.m. To get her money brought current. Ms. Vaughn, you're going to have to be very persistent with Salvation Army to get them to move on this. But because the other two cases also were adjourned to August 30th, I think this one should be treated the same way.
Thank you, Ms. Vaughn. Your case will be adjourned to August 30th at 9 a.m. Mr. Landman, those are the only 3 things I have scheduled that day. So I will see you that morning. Ms. Vaughn, please follow the Salvation Army. I hope you feel better soon, ma'am.
Thank you so much, Judge Martin. Thank you. Thank you. I'll get it together.
Have a good day.
Thank you too.
Thank you, Your Honor. Stay well.
That's it. I love your office, sir.
We love you as well. We love all the judges there.
I'm talking about.
I'm not sure I can say that for all courts, Your Honor.
Have a good day, sir.
You as well.
Thank you. Mr. Morton, this is 221678 LT. This is M. Mark Concord versus Deza Oliver and Mark Simpson.
For the record, Your Honor, Attorney Ian Morton of Pallets Law, was on behalf of the plaintiff with a slightly cleaner office.
I miss that look. I miss that organized chaos, and I'm sure he can find every single thing that's in there.
Yeah, that would mean I need more medication, I think, Your Honor, to be able to deal with that.
Today is the day and time set for hearing on plans request to lift the Sarah stay. That stay went into place on April 27, 2022. 97 days have passed since then. Mr. Morton, has your client received payment or notification regarding the status of the Sarah application?
No, they have not, Your Honor.
This
Was it
case
the
hasn't
last?
been scheduled.
Oh, I'm sorry, I was gonna say the last payment received, was it on the account for Mr. Oliver and Mr. Simpson? Was it according to their records, was back in April of 2022.
Thank you, sir. This matter having been scheduled for 10:45 a.m., it now being 10:58 a.m., defendants having failed to appear, this court will lift the Sarah stay. As for the remainder of the balance that is due and owing, Mr. Morton, how do you wish to proceed?
Here at this time, we would ask a default judgment for possession be entered. Was it as of today's date, which includes the month of August? The rents retained are actually, sorry, Your Honor, one moment. I'm having a slight calculation error on. Total balance due and owing is $6,147.10. Core cost of $169 for a total of $6,316.10.
Defendants having failed to appear as directed by this court, default judgment shall enter in favor of plaintiff and against defendant with rent to retain possession of $6,147.10, $169 in court costs for a total judgment of $6,316.10. Plaintiff's office to submit that default judgment. Anything else in this matter, Mr. Morton?
No, Your Honor.
This is 221681 LT. This is Ammark Concord Club Apartments versus Marcellus White. Mr. Morton, the court notes your appearance for the record. This case was scheduled today at 10:45 a.m. for hearing on plans request to lift the Sarah stay. That stay went into place back on May 4, 2022. 90 days have passed since then. Mr. Morton, has your client received either payment in full or an update regarding the Sarah application?
No, they have not, Your Honor. And the last payment they received on this account was February 14th of this year.
Defendant having failed to appear, the court will lift the Sarah stay. As for the balance of the rent that's due and owing in this matter, Mr. Morton, how do you wish to proceed?
Here at this time, we'd ask a default judgment for possession be entered. Rents retained are $6,283.00. Core cost of $169 for a total of $6,452.00. I would state that for the record, the Sarah application that from our understanding was in place was a recertification. So even if the recertification did come in, there'd still be a large portion of balance to be paid by the tenant.
Thank you, sir. This court does have that from the May 4th date that it was a recert-1. In any event, this matter was scheduled for 10:45 this morning. It's now 11:01 by the court's clock. Defendant having failed to appear, Sarah state being lifted, the default judgment shall enter with rent to retain $6,283. There's $169 in court costs for a total judgment of $6,452. Plaintiff's office to submit that judgment. Mr. Morton, it appears to conclude your docket with this court this morning.
Yes, it does, Your Honor.
Have a wonderful day, sir.
Thank you very much. You as well.
Thank you. Mary Ann, that's it. I will take us down. Our next case is a live hearing at 1 p.m.
Okay.
Thank you, ma'am.